we'll jump right in to PAGA. This is the biggest question we're getting from employers and the clients right now is how do we protect against the Private Attorney General's Act claims, the PAGA claims? And as this chart shows, there've just been more and more PAGA filings. Part of this is due because of the class action waiver that you can build into arbitration agreements. And we've spoken to a lot of our clients about implementing these arbitration agreements. We'll talk about it here as well today. But for most employers, if you've got 40 to 50 employees, it makes sense to implement this arbitration agreement with a class action waiver. And so it protects you on the class action front, but California Supreme Court has said, well, you can't waive a PAGA claim, though, in these arbitration agreements, even though federal law permits employees to waive their ability to bring a class action. They can't waive their right to bring a PAGA claim. But we still think there's a lot of benefits in having an arbitration agreement with a class action waiver. And it opens some other arguments for us in defending a PAGA case when we can compel the individual plaintiff to arbitration, try their individual wage and hour claims in arbitration, see what holes we can put into their claims, and it might impact their ability to bring a PAGA case back in civil court after the arbitration. So there's still some benefits on that, and we'll talk about that here briefly, and we can walk through other questions as you guys have throughout the webinar here too. So some steps to protect against PAGA claims. I mentioned the arbitration agreements, probably the biggest one that you can do. And again, you can't waive PAGA, but it does open some arguments for us to defend against the PAGA claims when we have an arbitration agreement in place. Again, we can get the individual off to arbitration, most likely stay the civil lawsuit, the civil PAGA claim, try their individual PAGA claims as an individual, see if we can maybe win that in arbitration, or at the minimum, create issues, individualized issues that are particular to that plaintiff only. And then it's going to be tougher when they come back to civil court to bring this PAGA case on behalf of everybody because it's so individualized. So there's a lot of benefits there. And the big benefit too is you get a class action waiver. It makes sense having that as well. And then really just tighten up your wage and hour policies and audit routinely. And we're going to be talking about these items here in the next section. So meal and rest breaks is still the number one PAGA claim that we see. Timekeeping and overtime claims, we see a lot of those. We're seeing a lot of expense reimbursement claims coming in as well. And then just the basic records and pay stubs, make sure we're compliant on that. And then we're not seeing a lot of PAGA claims enforcing California's paid sick leave, but there was a case that just came out last year saying that plaintiffs can bring PAGA claims against employers for the paid sick leave, California paid sick leave violations. So we expect that to see some increase here over the next year or two. So we'll talk about that as well. And then the big issue is train your frontline managers about wage and hour policies. It's great that you as the executives know about the meal and rest break requirements and all of these other requirements and are maintaining records. But if your frontline managers don't understand when breaks need to be administered or taken, what if somebody misses a break, what to do, your policies are really, it doesn't still protect you. The frontline managers need to understand this and be as knowledgeable as the executives are about these policies. So we're a big proponent about training managers, getting them up to speed.